trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome. I hope everybody had a wonderful Thanksgiving holiday. Today we're going to be listening to the cases in Judge Jeffery Middleton's courtroom. So this ought to be interesting. So let me share screen. Let's go back to StreamYard and make that bigger.
Good afternoon, Mr. Lamnon. Thank you for being here early and on short notice. I'm going to get right to it. I have a very busy afternoon today. I had to cancel my sobriety court staffing for this. which I didn't want to do, but thank you for agreeing to appear on this short notice. It's titled Centerville Mobile Home Park versus Shauna Zerley. File number is 252106LT. Shauna Zerley is here with me in the courtroom. She emailed, I wouldn't exactly call it a court filing, and she hasn't paid a filing fee. She emailed a motion to stay eviction and motion to set aside judgment, motion to stay execution of judgment, motion to set aside vacate judgment, on a number of things in an email. She then also today dropped off a bunch of stuff to the clerk a short time ago, which she's still trying to get date stamped and scanned in, so I haven't seen it yet. I wanted to try to address this before Thanksgiving, which is why I crammed it in here. The defendant is here in pro per. Legal aid will not be representing the defendant. Megan Bauer told me or us that she would not be representing this defendant and that they did not accept her as a client. So she's in pro per. We had a first hearing on November 7th. We had, me being the court, had some confusion about how much was actually due. There were issues about how costs were calculated, what were late fees, what were utilities. So we rescheduled the matter, as we always do, for a second hearing, and that was heard on the 14th of November. And the parties were placed under oath, and I took testimony and came up with a figure that the amount owed. This is a demand for non-payment of rent, not termination of tenancy. I found that the amount owed was $2,752.69, $169.84, and cost for a total of $2,922.53, I think it is. And the date for the writ theoretically would have been Monday the 24th. I wasn't here on the 24th or 25th. As I indicated, it is a non-payment of rent case, and it allows removal of the trailer. The defendant has filed a bunch of stuff, not paid the motion fee, and asked me to stay these proceedings. We took testimony on the 14th, as I indicated. Both parties were sworn. And it was actually a lower figure than before. So the defendant has raised a number of issues here that I don't think were raised before. Ms. Zerley, what are you asking me to do?
Well, their math isn't mathing. I did make 2 payments that I was ultimately told by them that did not go through, but they did go through my bank. So I ended up paying them, and I don't have the paper in front of me, so I don't have the exact figure. It was over $2,000 some, which leaves me a credit of $100 for the month of November. And there's in their system, when I sign on, it even shows that, and it shows that I made the payments also. I did include some of my bank statements also. There's a lot in there, and I'm sorry, I try to keep it minimal.
Well, we took testimony under oath. Ms. DeCenzo is here, and the manager, Jessica, is also here, Jeshua. Ms. DeCenzo's testimony was no payment had been received, I believe, since June. There are often issues with these new payment methods where they can only pay through a payment portal, and you can't go give cash to your landlord anymore, and it costs you a fee to actually pay your rent.
And it cost me several fees to pay.
But I don't believe that you made several $1,000s worth of payments that you weren't credited
Their
for.
records even show it, like the bills that they dropped off on my door. And they didn't apply the accounts to my account. And the thing that's really disturbing to me is I tried to get a hold of Miss DeCenzo yesterday. I think I missed her call. I have two portals that I can log into. One of them shows that I didn't pay and the other one shows that I have paid. Now, why I have two different portals from them, I have no idea why. But they're completely different login information. She did have me set up a new account. I think it was in August when I did pay. I paid August 8th and I think it was 14th possibly.
Your Honor, if I may, we're covering old ground here.
Yes,
This was argued on the 14th. As was noted on the 14th, there were two payments that were made and returned NSF. And you noted that as you calculated the amount due. As far as today is concerned, obviously I didn't have an opportunity to get a response in, and I haven't seen whatever was dropped off this morning.
neither
What
have
I
I.
would-
It's a big
yeah.
pile of stuff that has been handed to me about 2 minutes ago.
So what I would say is, firstly, if there's a motion for stay, it should have been accompanied by 1 month's rent as a bond. If there was no filing fee paid for the motion, I'm guessing there was no month's rent deposited with the court. I would also indicate that what this seems to me, at least in part, would be a motion for reconsideration. And for that, the tenant defendant would have to show that there was a palpable error on the part of the court. And looking at what was sent by email, I did not see any kind of palpable error. She argues that she was somehow entitled to a public defender or legal aid to represent her. And I think we have established that certainly was not going to happen. In addition, she's making the same argument, it sounds like this afternoon, that she argued on the 14th. I would indicate to the court that at the time that the court entered the judgment and noted the payment deadline of the 24th, it indicated that it was not likely to sign any kind of order of eviction until probably December 1st, just because of the way the holiday broke. And in fact, with this motion having been filed, we have not yet submitted the order of eviction to the court. We're prepared to send it in as early as today, but the court's not going to get it or look at it until after the weekend. So there is still time for Ms. Zierle to move without having an extra month's rent added to her tab. I think the court handled everything properly on the 14th. It took extensive testimony from Ms. Zierle. It evaluated it. It credited her for some money that had been assessed because it felt that the late fees were too high. Therefore, the judgment amount was less than the amount that was showing on my client's ledger. And I see no basis at this time to revisit anything that the court did on the 14th.
May I speak?
Yes.
But you haven't seen what I have and neither has he. I don't feel that I had another person to back me up as I needed. And I felt like I got railroaded. And I feel like what I do have needs to be looked at and it needs to be considered no matter what was decided on the 14th. I did state when we first started that I filed that I needed some help because of an ADA accommodation. And that was under oath. And
I looked for
expected
that. I
things
couldn't
to
find it,
stop
but let me,
at that point.
this is a matter of paying your rent or not paying your rent.
Yes.
It's not an ADA. They're not terminating your tenancy for just cause. There are certainly accommodations we make for people with,
I just needed help speaking for
right.
myself.
okay. I'll concede that. We had 2 hearings, lengthy. I blocked out a bunch of time. I knew it was going to take a long time. Then immediately after you file all this stuff like throwing spaghetti at a wall to see what will stick. You didn't pay a filing fee. You didn't file it properly. You just emailed it to
No,
the
that
court.
was-
Now, you're not a lawyer. So this morning, like an hour before the hearing, you drop off all this stuff. It's your contention. You're not under oath. and I said, I don't believe you, but you're not under oath, that you've paid all the delinquent rent and you should actually have a credit.
It shows on the paper,
All
on their
right.
paperwork.
Show me in here, you find it, show me where it says you paid your rent.
Well, you look at these two. Like there's credits up there. They were never applied to my account. They're just showing up and showing up and showing up. And here's the bank statements. And this is showing, it shows up like this when they've received a payment. For it's showing that I have a credit of $100 and some as of now. Even when I log in, like it won't let me even pay anything if I wanted to online. But I circled a bunch of things for Christy and I sent them back to her and I was like, it shows.
Couldn't have a seat.
So there was two different things that happened with my bank.
Well, sit down,
Okay.
sit down. All right, Ms. DeCenzo testified under oath that they haven't received any money under any account since June. And I agreed with that. I substantially reduced the amount they were asking for by reducing late fees and some other things that were unclear. And I came up with that number after taking testimony. The way the trial works is you don't come in 4 days later and say, well, here's all the evidence I should have had at the trial. Plus, I can't make head nor tail of it.
I entrusted for Meg
All right,
to,
so they want you to move your trailer. And I suspect you've done absolutely nothing to move your trailer. So what you want them to do is take your money and let you stay there.
they already have my money.
All right.
I can't go anywhere. I'm halfway dead as we speak.
I don't believe they do have your money. And I would need someone from the bank to testify,
Okay.
not just some papers that are printed off a screenshot.
I didn't pay because I knew it would come to court. I didn't pay for 2 months and then I ended up paying and she told me she hadn't received my payment. And then she did get my payment and it shows. And it's even on all the bills they put on my door that they received that money. But then all of a sudden they come up with all this money that they need me to pay. And if you look at all the paperwork, you'll see where they just.
I don't see it. I see where it's so small, I can't read it. It's a screenshot from something.
It's from their account
Um,
where I log in online.
I can't even read it. All right. So you're asking me to do a number of things. You're asking me to stay the proceedings because your contention is we haven't seen this evidence that establishes that you've paid the rent. We took testimony that you haven't paid the rent. In fairness to Mr. Landman and Ms. DeCenzo, they haven't seen any of this stuff that you laid on me at 11:45 this morning. And so I can't tell what it shows. I suspect when Ms. DeCenzo goes through it, she's not going to change her current opinion.
She's not.
That you owe the money. And the point of fact, they didn't do it as a just cause termination. It would have been a lot easier if they had. I mentioned that last week, and there's no reason to beat a dead horse. It's going to happen until after December 1st. We've never actually, I haven't seen one of these that's been executed. Let's say they hire a company, Kramer Trailer Moving Services. They come up, they disconnect your gas, your electricity, your water, and then they pull the trailer off your lot. I don't know what they do then.
I've tried
Take it to
move
Walmart parking lot and park it?
I tried to get help to move because I don't want to be there because of the things that have
Well,
happened.
that's the other stuff. You told me what a terrible place this was and how much you hate being there and
But
you're
I'm already
unsafe.
half
been
dead. I don't
assaulted.
see any point in trying to move right now. I don't know how much longer I have.
Well, none of us do. Anyway, I haven't signed any eviction order. Oh, you came in at 12:50, not 11:50. You came in at 10 minutes before the hearing and laid all this paperwork on us. I did set this on short notice because I wanted to deal with it.
In all fairness, Meg had this on the 7th and I thought she
Meg
was
is not going to be
I
representing
thought she
you.
was
She
going to show you
indicated that
guys then.
she was not going to be able to establish an
She
attorney-client
never told me
relationship and
that.
they would not be representing you. And she wasn't here at the hearing. They don't get court-appointed counsel for civil matters. Maybe it'll come at some point, but it'll be extraordinarily expensive. We don't have enough coverage for criminal matters where people are in danger of being incarcerated. If they have court-appointed counsel for civil matters, we're talking billions of dollars, so we presently aren't there. But nothing is going to happen imminently. Mr. DeCenzo, Ms. DeCenzo, I don't know if you guys have contacted a company, and I don't know what they're going to do. You're doing nothing. You're doing nothing.
I don't know what I'm supposed to do.
You're supposed to find some place to move your trailer to. You hate it there. You don't like them. You feel they're unfair. You believe you were
They need
assaulted
to be
in your own
audited.
home. And you'd like to move, but you haven't done anything to find out
No,
about
I
moving.
haven't. I don't have the energy to move. I don't have the energy in me to fight anymore.
Well, the money that you claim that you paid, which they contend you have not, could be used to pay for the move of your trailer.
Yeah, I could. I've tried to get the county to help me move it after what's happened to me. And
Well-
heard of no such move, no matter what.
Well, ostensibly, yes, they do.
Well,
Now,
she has called me several times and tried to get me to sell it before we even came to court.
now that in the other ones, there's an option. You have 90 days to move or sell the mobile home.
Well,
And so very often they work out some sort of an agreement where you sign the title over to them, they forgive the arrearages, you don't have to move the mobile home. And then, in fact, I think that's usually what happens.
It's unfair to make me leave.
Why?
I'm not the problem. A lot of things keep happening to my home. It keeps getting broken into over and over and over and over. I'm not the problem. They're aware of who the problem is and they're not taking care of it. So I find it unfair and unfit that I am the one who has to move. Just because someone doesn't like me and they're causing a lot.
Well, they argue that you're not paying your rent and you haven't paid the rent since June.
They've destroyed my trailer.
Well, they haven't.
I would rather pay a lawyer than pay them. Because I know I paid and they know I paid, and I don't know why they're doing this. Other than the fact that I feel like it's retaliatory. Just like my garbage can gone, just like my rent keeps going up, knocks on my door, asks me where I'm getting my medication now, the day that I change it to a different pharmacy. Why would they need to know that? Because my medication keeps getting stolen out of my home. Like, this stuff is just ridiculous. These are the things that I've been dealing with. I don't want to be there, but I can't move my trailer. I'm not gonna move my trailer. I just want to stay and I want to be left alone. And I want things to be fair.
Your Honor, if I may, my client is willing to discuss with Ms. Zierle either purchasing her home or accepting a transfer of the home in exchange for a waiver of the rent that's owed. But under either scenario, Ms. Zierle is going to have to move. And what would likely happen if an order of eviction were issued is that the first thing that would occur is that with the assistance of a court officer, Ms. Zierle and her belongings would be removed from the home. My client would have 56 days from the issuance of
No,
the
they
order of
wouldn't.
eviction.
No, they wouldn't. They would not be removed from the home.
I'm too old for this.
you have the right to move the trailer. You do not have the right to remove anything from it. So you've got all kinds of liability issues here by doing it this way. No, she doesn't have to move out. Under a just cause, she does. She has 10 days to vacate and 90 days to move or sell the mobile home, but you didn't do it that way. So you have a right to haul the mobile home off of her lot. She doesn't have to vacate. She doesn't have to move anything out of there. Under the other way that nobody does, she would. Now, again, here today, nobody's under oath. We were last week, and Ms. DeCenzo testified, and no money had been paid. So essentially, she's arguing the same thing. 10 minutes before the hearing, she filed a bunch of pleadings that I can't read that contends that she's paid the rent.
And that puts us in the same position as we were on the 14th,
Yes,
Your Honor, because you concluded
So,
that her payments had been returned to NSF, which is in accordance with what had been testified to by Ms. DeCenzo.
NSF can also be considered a credit. That needs to be looked at.
no, that's your contention that the NSF should be credited to your account?
That's not what I'm saying. NSF. Now, NSF can mean they tried to pull from rent manager and from pay lease. It only pulled from one. So it got returned to pay lease, but not rent manager, if that makes any sense. They tried to pull it twice through the portal, and I'm not sure exactly why. My paperwork does show that. And it does show where it was taken, and it shows that I was actually charged by rent manager to pay that payment, both of them. The amount and the $1,118.11 and the amount and the $1,228 and some odd cents.
Yeah, we took testimony on that matter on the 4th.
I know you did.
And I didn't make that finding. One option I'm considering, Mr. Lamon, is
You can see in the paperwork that I paid.
I can't see anything in this paperwork. I can't even read it. You filed it 10 minutes before the hearing and it's so small, I'm gonna need to magnify it to read it. Plus, I don't know what it means. I'm not an accountant. I don't know what the bank's policies and procedures are. It needs an expert from the bank that can tell me what happened to this money. I'm contemplating setting a hearing and entering an escrow order, which she has to pay December and November's rent, which is money she could use to move. November's rent is long past due. December's rent is about to be due. What's that?
I'm fine with paying November and December.
But I already made a finding. Multiple problems. Mr. Lamon spoke to these. You didn't file a proper pleading. You sent an email to the court.
I asked.
You didn't serve a copy on the other party. We had to do that. You didn't pay the filing fee.
I'm okay with. I'm not a
that.
lawyer. I had nobody to help me.
I know you're doing the best you can. But I already did it. And I resent the fact that I had to cancel everything I had that was scheduled for this afternoon to hear this a second time because you didn't like what I ruled the first time. Mr. Lamon, one of the problems is she's filed all this stuff. I could simply say it wasn't timely. It's filed 10 minutes before the hearing starts and she didn't serve a copy on the other side.
I did what I was told. I was told to come in 15 minutes early.
Well, yeah, that's
you can get
fine,
that
but not
paperwork.
come in 15 minutes early and file your
That's what I
pleading.
was told. I'm sorry.
All
If I
right.
was told differently, I'd have done it differently.
Mr. Lehman, any final words?
Your Honor, all I will say is that even though that Ms. Zierle is representing herself, she is still obligated to do things in compliance with the Michigan court rules. The court certainly had the discretion to expedite the hearing, and I appreciate the fact that it was trying to deal with this promptly. But as far as a basis, certainly as a basis for setting aside the judgment, there is none. And there's really no basis for a stay either without a bond having been paid, without the filing fee even having been paid. I think this was simply a situation where Ms. Zierle was attempting to buy time, and she succeeded to an extent. Even if as I mentioned before, even if the order of eviction were submitted today, you're not going to see it until Monday. And what you choose to do with it at that point, as you have noted, Ms. Zierle is unhappy living there. She wants to continue living there, I guess, for free, and she should.
I'm not trying to stop anything.
Stop. It's his turn to talk. Go ahead, Mr. Lehman.
Yeah, and that's really all I have to say, Your Honor. I think under the court rules, she hasn't met the conditions for reconsideration. She certainly hasn't met the conditions for setting aside or for a new trial. So where she's left is that she would have, or she's running out of time, or has run out of time even to file an appeal in circuit court. So I think that this was sort of a Hail Mary type of situation, and I don't see where the Hail Mary should be completed for a score.
I had a case recently where the case was being appealed from district court to circuit court and asked for a stay. And the circuit court said, ask for the stay, and you can ask for a stay in the circuit court. All right.
I don't want to go, and I'm not trying to stall any time, and that's not what this was about. I thought I had someone to back me up in court. She had all my paperwork, and then when we returned the 14th, which I spoke to her before the 14th, I thought she was going to be there with my paperwork to back me up. This is not me stalling. This is me trying to be fair and try to get a fair judgment.
And by she, you're talking about Meg Bauer from
Yes.
Legally?
And I'm trying to do everything within the court's judgment and whatever you want to call it. I don't know the proceedings. I don't know what they are. I'm not a lawyer. All I've done is call and ask questions and try to see what I need to do. And I'm still lost as that goes. But I don't feel that I should have to leave. Their math is wrong. And I don't appreciate getting threatening phone calls from her either. And I don't know if you read that or not. And I'm not making that up.
Well, since I didn't see it until 1 minute ago, I guess I didn't see it. Who made threatening phone calls to you?
She did. She was
She
laughing.
she who?
Ms. DeCenzo,
As of when?
before court, before the first hearing, they kept calling me like 3 weeks before court, asking me why I hadn't left yet, telling me I needed to sell, and if I didn't do this or that, they were gonna.
Well, one factor, you need to be able to speak to each other. Mr. Landman's suggestion is that you would somehow transfer title of this to them and move.
I don't even know that I have it. I'm not sure whose name it is anymore because all that stuff was stolen out of my house. I don't even know if my car is in my name anymore. I'm being honest with you.
All right. Motion to stay is denied. Motion to set aside the judgment is denied.
What I guess in child kindergarten terms, I'm gonna need you to explain to me what that means.
Means they're gonna move your trailer off of there unless you agree to move it or transfer it to them.
So
They
I
cannot
can't
move
say.
you out of the trailer. They can't have the sheriff come move you and your stuff out. This isn't that kind of an order.
So I'm
is an order
essentially
to-
gonna be homeless because I can't get a loan and I cannot get help. I've already tried to do all of that.
Um,
That's
Per-
cool. Happy Thanksgiving.
perhaps. Uh,
She told me she would do this to me and she would make sure that that happened.
My goal isn't to make you homeless. My goal is to try to follow the law. And they filed this, they filed all the proper procedures. I'm allowing to do this, as I indicated. I wish they'd done it differently, but I gave the order that I gave. I took testimony under oath. Legal aid is not representing you. They indicated then, they've indicated since they will
And
not
I
be
also told you I
filing an
needed
appearance in
help.
this case.
A lot of times I see you, oh, I think you might need a lawyer for this. You didn't even offer me that. I don't know what I'm doing. All I know is I paid what I paid and they are trying to get more out of me than what I personally gave me themselves and hung on my door. It literally says I paid them.
Well, the sworn testimony was no payment has been made since June of 2025. And that's the finding that I made.
I paid in
And I
August.
greatly reduced the amount owed. I believe their version more than I believe yours.
It's not a matter of whether you believe me, it's what is on paper there in front of you. And
I don't want to argue about it
shows
anymore.
when I
You're
brought
gonna
it
have
in.
to
I
prepare,
can't even make a payment.
you're gonna
I
have
have
to,
a credit of $100.
I did not make that finding.
All the
um,
paperwork is in front of you. I don't enjoy, the only reason why I haven't paid them is because I paid them twice. And if you look through that fudgery of clown paperwork, it's not funny. Like, I don't know why they're trying to do this. Jesus knows, or Jessica, or Jessie, or whatever you want to call her. She knows I paid. I know she knows. I know she knows I got it. I'm concerned that they should do an audit on the whole trailer park because I guess I'm not the first person this has happened to. I've even asked her how much my rent is supposed to be because I think I'm paying a ridiculous amount of rent for living there opposed to other people. Why is that? Why don't I have a garbage can? Why was mine taken away and nobody else's? Like, this is just all retaliatory.
All right. They prevailed. I'll do an order, Mr. Landman.
Do you want me to submit one, Your Honor, or is the court going to do it?
No, I'll prepare one.
Very well.
So your options are to move your stuff out and leave your trailer there. Move your trailer to somewhere, or negotiate some sort of sale or transfer to the park for the.
Yeah, they offered me $500 in my keys.
I don't know the answer to that. I don't know how much the trailer's worth. In fact, I don't even know if you have the right to transfer the title to it.
I wish you would take the time and just really look through that stack. I know that you are.
I've made my ruling and I stand by
You
it.
did, and you made your ruling on the 14th, and I told you at the beginning of that I needed help. I had filed an ADA for a reason.
You didn't file
I
an
cannot, I
ADA.
did.
I
I
paid,
did before that court
All
date,
right.
and I told you under oath, and at that point, all proceedings should have stopped.
for what?
It's part of the
Someone to-
law. It's part of my rights.
All right, then you
And I
can
felt
appeal, you
railroaded.
can appeal this to the circuit court and ask for a stay there. I don't think I'll grant one. They don't want you there.
don't
If you
wanna
had
be
a
there,
big
but
pile
I'm-
of money, you could pay it all. And I'd
I
have to
probably have a
accept-
year left of
Well,
my life.
here's one, I told you how much you owed. Pay it.
I'd rather pay a lawyer and have them look at that stuff than pay them.
Well, that's up to you. I told you in clear English that through November, now shortly December will be due. I told you after hearing, $2,752 $1,000,000.69 in rent and a court cost of
I paid
$169.84.
in August. I had $3,000 in my account
all right.
in August, and then I paid him, and I
Well,
have
then-
500 left.
You
Where'd
owe
it go?
$2,922.53. Mr. Lamon, she gave all this stuff to us at 10 to 1. We scanned it. I'll send it to you, but
Your
please
Honor, that's
escort
not
us early.
necessary. Your staff already has done so.
All right, thank you. That's the cure. Pay it. All right, you're good to go. I
Thank you, Your
suggest if
Honor.
you want to stay there, you pay them rather than a lawyer. Of course,
But it
December's
sounds
rent.
like I paid them and I'm still not staying.
Well, if you pay them, you get to stay. That's pretty straightforward. You'll just under $3,000 through November. If you pay them rather than a lawyer, then your rent is current. I made a finding on how much the rent was due. All right, please escort her out. I don't have anything else to say. I don't want to
Can I
argue
get my
about the same thing.
paperwork back? This is what I want to ask.
Well, you file it with the court. Well, you did scan it, so I guess I'll give it back to you.
Okay.
Show that it was.
I mean, I didn't make a million copies of everything. I'm not violent. There's no need. I just wanna
You're
know if
free
I
to
can have
go.
my paperwork back.
Thank you, Your Honor. Have a happy Thanksgiving.
All right, thank you.
Well, Ms. DeCenzo is waving her arms and she's muted.
I
That was not a
apologize.
good answer to that question, but that's my ruling and I'll stand by it. And I wish you would consider filing termination of tenancy, wrongful, just cause terminations in these cases that make our life easier.
The problem,
guys
Your
can-
Honor, is that in order to fall under the just cause statute, when the tenant is behind in their rent, you have to have filed on them 3 or more times in the course of a year.
Yes, 3 times in a 12-month period.
Right.
That's
So-
the way everybody used to do it.
So that
And
if the
that's the way
tenant is
some
2 months,
judges-
if the tenant is 2 months behind, for example, you'd have to file on the tenant, and you can't file as a just cause, so it has to be as a non-payment. And you have to do it 3 times in a 12-month period.
Yes, I'm aware of it, and I'm
Yeah.
aware some judges won't let you do it. You can't do this in, you can do it in Kalamazoo, you can't do it in Livingston. There are some other jurisdictions that say the law isn't clear. And I said this before, we need a change in the court rule, a court case, or a change in the statute to make it more clear, but so far as no one's appealed this. But your remedy is untenable. You have a right to come take her trailer off of there and move it somewhere, in which case you incur all kinds of liability. If you break the stuff that's in her trailer, you leave it somewhere and it gets looted. It's not a good solution to the question, but all right, that's my first crisis of the day. I've got another one here in just a minute.
You
All right,
have
I'll
my
see you next
condolences.
All right, thank you.
Where does that leave us? Sorry.
You can
Your Honor.
discuss that with your lawyer.
Okay.
All right, thank you. All right, that was not a very satisfactory ruling for anybody, but I made my ruling on the 14th, and I believe it was accurate. And I don't believe the defendant has had her account dinged for the amount she claims. So we'll stop the live feed. We have a PPO matter, which I do not live stream. There's a federal.
This is called a Shishibo cube. And
Good afternoon, Mr. Moore. How are you?
Good, how are you?
All right, it's time for our final pre-trials. All right. This afternoon, we have several. Mr. Bush, have we resolved Mr. Castro?
I'll need copy of the interpreter.
Will you open the Zoom room for us? Mr. Bush, have we resolved Morgan Kinsey?
Morgan Kinsey's here. We just have to call them.
She is here. She's
She is here. Okay.
Miss Klusterman is in custody. She got arrested for other things.
I just
She's in the back. Is that one resolved? She's got jail time. All right, well, we'll see. Casey Willis. Luke is in Three Rivers. He texted and he's running a little late. He'll be here. Brian McDowell. You guys are talking about that one right now.
Yes,
all right, we got a lot of uncertainty here. They're opening the Zoom room. Why don't you take your client in there, and Tim will just hurry up and wait.
Yes, sir. The Spartans were pleasant surprise.
Boy, that was fun to watch. Lucas or Colin and I were downstairs. We had the fireplace on, and you're always waiting for like something bad to happen. When they got it down to 10, it's like, oh no. But then when they opened it up again to 20. That Kentucky team is better than that. They got a bunch of really good players that haven't played together. So by the end of the season, that'll be a different kind of team.
I think the Big Ten's going to be pretty tough.
I think it is too. Get all these early wins we can get. All right, we have the live stream on for reasons I'm not clear on, but I thought we were ready to begin. Apparently we weren't as ready as I thought. He said Luke said he should wrap up by 2. This is the only case you've got?
Yes, sir.
All right, well, we're going to do it first, and still no Pablo. I thought there was correspondence with a translator in this file. Interpreter correspondence. No, it's for a previous hearing. Abby, do we have anything that's ready?
It doesn't sound like it.
Well, we need Luke. John's got several. Frankly, I was hoping all of these would resolve, but maybe I'm too optimistic. And Mr. Moore's talking with his client right now.
Yes.
Okay. All right. We're not on the record, but we are on the live feed, so I'll just let everybody know. I don't know how people did today. Been beat up and battered around. Been sent up, but I've been shot down. You're the best thing that I've ever found. Be better if I sang it, but when I read it in that deadpan voice.
This is the 1400.
I just logged in as misdemeanors. And Margaret, do you think you could set up some sort of payment plan to resolve this case?
Yeah. I can do that. I can't do a whole lot, but I can do some.
All right. Are you still living on lot 22?
Yes.
All right. I'm going to put you in what's called a breakout room with Attorney Francis. She does a lot of this kind of work, and she's willing to discuss setting up some sort of repayment plan. You should go into it automatically when you're here by telephone. I hope so anyway. So it's going to put you in a private space called a breakout room where you can talk with the attorney, and then I'll be here waiting and be ready to proceed.
Okay.
So thank you, Ms. Francis. I'll be right here. She's got her earphones and she's ready to go.
Thank you.
All right, and then you guys get to watch me sit here and reread my pre-sentence reports for my sentences at 10:30 and 11. I also have a 9 and 9:15, 2 9s and a 9:30. One of the 9s is resolved, so this has not been bad to be doubled up. World's most boringest live stream. I have 4 sentences.
My energy bill dropped from $150.
Two at 10:30. 2 at 11.
We are ready. She's on a phone, so she has to get taken out.
All right, let me close the breakout room.
And then I do have a 9:30 with you as well, Judge.
Okay, that would be Mr. Pirro.
Yes.
All right, well, I'll see you in an hour then. All right, Miss Hargett, can you hear me?
Yes, I can.
All right, the parties were placed in a breakout room and allowed to discuss the matter. Ms. Francis, what's the status here today?
We have agreed to a consent judgment. It is for the full balance, which is damages of $819.85. Cost
I got
of $190.
817.
I'm sorry, Judge.
You said 819, I've got 817.
Oh, if I said 19, I apologize. I don't know what I'm reading. It's
Okay.
$817.85 plus cost of $197.44 plus the $75 attorney fee. So the total is $1,090.29. And we have agreed to $25 per month beginning December 5th and by the 5th thereafter. And she is giving us permission to sign the consent judgment.
Ms. Hargett, did you hear everything Ms. Francis says? Some of it was kind of
Yes,
hard.
I did. Yes, I did.
All right, you agree to repay this debt plus the court costs for a total of $1,090.29. You agree to pay it $25 per month, which will take a little less than 2 years to pay this off, starting December 5th. And
Okay.
you agreed to that and said that we can show on the record that you did consent to it. Is that acceptable?
Yes, sir.
Did she give you instructions on how to make the payments?
Yeah, she told me to contact the law office, which I have
All
right
right.
here.
Very good. Ms. Francis, could you send me a consent judgment?
Yes, Your Honor. I'll have the office do that.
Ms. Hargett, did you feel threatened or pressured to enter into that agreement?
No, sir.
You acknowledge that you owe the debt and you're willing to pay it off at $25 per month?
Yes, sir.
All right, very good. I hope this is a better year for you. You've had a rough go of it the last few years. And let's
Thank
see if we
you.
can get this paid off. Now, you can pay this sooner if you get a tax refund or you sell a car or you inherit some money or
Okay.
something. You can pay it off, and
Okay.
the sooner you pay it off, the sooner it will go away. But as long as you pay $25 per month,
I understand.
all right, you're good to go. Thank you. All right, Ms.
Thank
Francis,
you.
I'll see you in about 50 minutes.
Okay, thank you.
Thank you. We have about a 19-minute gap, I'm gonna stay right here because people often come in early. Well, I think that's the way this cases are gonna be this morning. They're all pretty straightforward. So we have 19 minutes of dead air with me looking at pre-sentence reports. Sorry, sometimes it's easier to stay here. In the old days, I would have gotten up and just gone in my office and had a cookie.
Subaru and our retailers are the largest automotive donors to Make-A-Wish, supporting kids and families facing critical illness through the Share the Love event.
Get 0% APR on select new Subaru models, and Subaru will share the love.
Nobody wants a stained, dirty toilet.
Ugh.
But many cleaning products have chemicals that are harmful to the environment. And who wants to?
I hear both of you very well.
I can see you and the ceiling stain on your ceiling tiles. Ms. Shingledecker, you're gonna need to turn up the microphone on your, turn up the speaker on your computer.
I don't know what I'm doing wrong here.
All right, you're doing all right. I can hear you and see you, but the problem is at your end. Mr. Cox, I don't think today's first lyric is in your wheelhouse, but I'll give it to you. It's Monday morning. We were good, we were gold, kind of dream that can't be sold. We were right till we weren't. Built a home and watched it burn.
It's not coming to me, Judge. Might need another cup of coffee.
It's much more recent than our last discussion.
Oh, maybe that's what I'm.
Yeah, I'm good at 50 years ago, not so good at 2020.
That's kind of where I'm at. Unless it's my daughter. It's in my daughter's wheelhouse, maybe.
Yes, your daughter would know it. Ms. Shingledecker, can you hear me?
Yes, sir. Sorry.
Oh, all right.
She's real loud.
You're all right. You're all right. Thank you. I was doing non-work business here. All right. We had a lot of discussion about this matter back on September 26th. The bill here is 2009-98-24. Ms. Shingledecker was very dissatisfied with the quality of the service she received. and this bill remains unpaid. She claims that the surgery was botched, which caused her all kinds of issues and additional hospitalization and expense. And that isn't something you can just come in and say, hey, the surgery was botched. It's the kind of thing, as we discussed, you need an expert testimony to assist with that. All I know is that Three Rivers Hospital is now sending you this bill. So we adjourned this matter for about 60 days or 45 days to do some additional discovery here. Mr. Cox, what's our situation today?
Yeah, Judge, so when we concluded the proceedings last time, we went into a breakout room, the defendant and I thought did the framework at least for a possible settlement, to the extent that I had drafted a settlement agreement and emailed it over to Ms. Shingledecker's attention. I didn't get a response to it, but I thought we had sort of worked something out, but I'm not sure where we stand with regards to that. I don't know if we need to return to the breakout room or if Ms. Shingledecker has thoughts that she wants to share with Your Honor.
I do have some things to share. I was a little confused about I knew we made the arrangement and we settled on a dollar value monthly, and that was fine. I think I was a little confused at the conclusion of the last meeting because the judge said that he wanted to proceed with discovery. So I didn't know if I needed to wait for this to happen before I start making payments. So I apologize for my confusion there.
No need to apologize. Well, Mr. Cox, what is the agreement?
Well, Judge, we had worked out a settlement agreement with a conditional dismissal, so there wouldn't be a judgment as long as she agreed. The terms were to pay $75 monthly toward a balance of $3,138.56. We had the first payment due October 20th. We could probably bump it to, well, if we want to do a payment this week, it could be November 20th, or we could go all the way to December 20th, depending on how it affects Ms. Shingledecker. The settlement agreement.
That's what I prefer, is go to December 20th.
Yeah, I can probably even, we can either alter the agreement and I can re-email it out to you today. But then it goes on, Judge, as all the settlement agreements we've done before Your Honor. She's got a 14-day grace period to make these payments. But the agreement also provides that a conditional dismissal without prejudice, while she's paying, and then she agrees in advance to sign a stipulation to reinstate case in the event of default and a consent judgment for the amount paid for in the complaint, and that $3,213.56. So what I would need her to do is sign all four documents, return to me. What we do is we file with the court the dismissal and the settlement agreement. And then with regards to making payments, again, we can make that December 20th. The only thing I would note for Ms. Shingledecker is that discovery was sort of our backup plan. We wanted to settle this case from the very beginning. We have. The discovery process is something that we turn to if we need to proceed with litigation, have a trial or something, or we can't work it out. But now that we have, we don't need to necessarily engage in discovery. And I'm sure that's what Your Honor was about to say.
Yes. And it can be expensive too. So as I understand it, you've agreed to the amount, $3,138.56. They're going to file a conditional order of dismissal, which is a relatively new phenomenon. Means the case would get dismissed, it wouldn't show up on your credit record.
That would be
And
great.
you agree, I'm sorry, you agree to pay it at $75 per month starting December 20th. And then you agree that if you don't make the payments, they can reinstate the case, and then it would show up again, and then they could pursue collections.
Did you know that linen is the only fabric that
Excuse me.
Sorry, go ahead.
I'm sorry.
Does that concur with what you discussed?
Yes. And I agreed with everything that Mr. Cox and I discussed in September. Some things have changed since then. I lost my job. I got laid off. So I'm just getting back to work and need to get like all of my bills situated. So if December is okay, that would be ideal for me. So I at least have about a month to get my bills all back on track before I start this.
Where's your new job?
It's at Metal Technologies Industries in Three Rivers, Michigan.
Very good. All right. Now he's going to send you another copy of this conditional order of dismissal for your agreement. And I will tickle this for 14 days to file the conditional order of dismissal. Mr. Cox, you've still got her contact information?
Yeah, Judge, I just modified the agreement. It's Michelle, like, it's gonna be the exact same agreement that I emailed you previously. The only difference will be we changing the first due date from October 20th to December 20th. And then I will resend that to you probably within 10, 15 minutes. I will, it will continue to give you the payment instructions on the email that's on the previous one, and then the request that you sign all 4 documents returned into my office. So we'll try to get that done before the 14 days runs so that we can get this to the court in a timely manner.
4 documents to sign and return to you.
That's right. So I don't know why do in 1 document what you can do in 4. And what we do on this is we have you sign the dismissal as 1 document, the settlement agreement is 1 document, the stipulation to reinstate case and even default is a document, and the pocket judgment or the consent judgment that we hold on to is another document. We file with the court the dismissal, which is a good thing, and then the settlement agreement, so the court's aware of the agreement. And then we hold back the stipulation to reinstate case in the event of default and the consent judgment. Those gather dust as you pay. We tear them up when you're done. And so it works that way. So yeah, we do need all 4 because they all work together. They all reference one another. And then of course, the one thing I never noted was you can pay more than 75. It's like a credit card minimum. What you can't do is pay ahead. So you can't pay $150 in December and skip January, but you could pay $150 in December just to keep things moving and get done quicker. And you can always do a payoff if the mood strikes and you have the means to do so.
Okay. That total figure, the 31, 38, 56, does that include like court costs?
It includes the court costs, but not the attorney fee. So there is a distinction difference between the total amount of the judgment if we enter and the amount you're paying toward. And so that does include the filing fee and service of process fee, but not the $75 attorney fee. And of course, as we talked about, no judgment, no interest will accrue on this because of the conditional dismissal. So there's a benefit on your end to reasonable payment plan, no judgment, no interest, which is, I think, what the benefit on your end is toward this.
Thank you for that. I'm just trying to understand.
Okay.
If you have
more questions when you look at it, feel free to email me. Obviously, I think we've got it pretty much down, but if after now that you're taking a look at it very closely, if you have more questions, you can always email me.
Okay. Thank you.
Mm-hmm.
All right. Do you have any questions for me?
Judge, if there are any fees that I need to pay to the court, like separate from my payment arrangement with Mr. Cox, how will I know?
There is none.
Okay.
The filing fee and the service fee are included in this amount. Damages are $2,988.24 plus costs. That's the filing fee and the service fee makes the total $3,138. So you don't owe anything to the court.
Okay. Thank you for
I wish you the best. It sounds like you've got a good new job. Hope you can get situated, and I certainly hope your health gets back where it needs to be.
Thank you very much. I appreciate that.
All right.
Michelle, I can look for that email coming your way probably before 9:30.
Perfect. Thank you so much, Keith.
And Judge, one more question. The song?
The song is Flowers by Miley Cyrus.
Oh, see, no, we could have been here all day. And I wouldn't have got-
Like I said, your daughter would get it. I'll give you, next time I'll
No,
give you
and
something that's 30 years old and
Yeah, my
40
daughter
years
would know,
old.
like party. She would have I would have got Party in the USA from, but not.
You last.
This is one of my
Dealing with other matters. It is 9:30. Let's call this matter. This is Credit Corporation Solutions, Inc. versus Nathan Pirro. Attorney of record is Lynn Olivier. By limited appearance, Naviat Francis is here for the plaintiff. Mr. Pirro is not. Here he is now, it looks like. I wish we didn't allow phone only. Good morning. Are you Nathan Pirro?
Yes, sir. I am literally at work. I cannot, there's no video access here, so I have to call in. I'd love to come to the courthouse, so I live
What's
like
that?
3 blocks from there. I could have came there. Said I would have loved to come in person. I live about 3 blocks from there.
Well, you're certainly always welcome to do that. Let's talk about where we
Okay.
are and see how far we get.
Okay.
The distinguished Naviat Francis is here on behalf of the plaintiff, and this is Nathan Pirro. Title of the case is Credit Corporation Solutions, Inc., an assignee of Synchrony Bank, formerly known as GE Capital Retail Bank. It's a claim for $3,109.06. Once Mr. Pirro was served with that, he filed some documentation challenging the plaintiff's ability to pursue this case, wanted to establish that they were the current holders of this debt. Ms. Francis, what's the plaintiff's position?
This plaintiff is the assignee of this debt. It was a Synchrony Bank card that was opened May of 2020, and then it charged off in April of 2022. And we sued for the same balance that.
I'm having trouble hearing you. I'm sorry.
I'm sorry, is that any better?
Yeah, some. I had trouble last time too, but we got through it, so this seems better.
Sorry, I think it's my headphones. I think they're dying.
I think it is. Mr.
Take it off.
Pirro, can you hear her?
Yeah, I mean, it is a little quiet and she's breaking up, but I can hear her.
Okay, go ahead, Ms. Francis.
I did take my headphones off. I'm hoping that's any better.
Yes, it's way better.
Okay. This was a Synchrony Bank card. It was opened in May of 2020. It did charge off in April of 2022 for the amount that we did currently sue for, the $3,109.06.
Mr. Pirro, what's your response?
Okay. Well, I did send a list of things that they would have to provide to. I know she just mentioned, those statements, but she didn't mention how, the chain of title or command where they actually purchased the debt. So she just said that, credit or the PayPal was a charge off, and she never mentioned how they bought the debt, how much they bought the debt for, how they even collected or how they even were assigned it. So I also they sent me the same thing, and I'm sure you got that in a massive stack where they don't show any transactions or any, literally anything. It just is this one blank statement, and they printed out like wasted like 40 pieces of paper, and it's the same thing over and over again. So I don't see where it
Well,
proves
let's
that
take a
they
look.
bought
They're,
this
they're
debt
not
themselves.
entitled to tell you how much they paid for the debt, but they are
Okay.
required to provide a chain of ownership that they are.
Right.
So I'm looking for that. It's usually in here somewhere.
This is called a Shishibo cube, and let me show you what it does.
He did request that in each of his pleadings. I don't see an assignment of the debt from Synchrony Bank to Credit Corporation. The last case I did just a little bit ago had a clear assignment of title of the debt. I don't see it. All he got was the credit card notice.
Correct.
The original
And I
credit
have
card.
three different. I was sent three different things by them, and it all is just the same, thing over and over again. So I wasn't too sure.
All right, well, let's see what we can sort out here.
Is this the second pretrial, Judge, or the first?
This is the first.
So then discovery hasn't been opened for us to send him the chain of title. If we can get discovery
No.
open, we're happy to do so.
Am I allowed to speak?
Just a moment. His
Okay, you're
original
fine.
answer, which he filed right after he got sued, even maybe before. Yeah, they had trouble serving him, but he wrote a letter. This is a letter, is a formal dispute of the above referenced account you have reported to credit reporting agencies. Under the Fair Debt Reporting Credit Act, I'm requesting that you provide the complete method of verification, including the original contract signed. That's often difficult to do, but I believe that's in the pleadings. And all documents showing you have the legal right to collect this alleged debt. So they show the credit history and the credit cards in the original agreement, but I couldn't find an assignment of the debt from Synchrony to this plaintiff. Ms. Francis, were you able to find that?
Defendant's letter?
No, the assignment of the debt to this plaintiff.
We do have the documents, Judge. Like I said, discovery hasn't been opened yet, so we did not send it.
Your Honor, can I repel what you just said? The trial
Well, you
order
can
I got
certainly-
for the pretrial,
Yes?
the trial order on literally number 7 says discovery is now cut off except for motions to compel under MC R2.313. So what she's saying seems to contract that.
Well,
And I asked for that 3 months
I'm gonna
ago.
allow,
So.
I'm gonna allow it. I'll tell you how old that order is. Judge McManus created it. And I've been here for 23 years. So, but he requested it. They didn't respond to it. They claimed that there was no discovery open, but it's a simple question. Do they own this debt or not? During the stock market crash and credit issues, foreclosure issues after 2008 and 2009. We had lots of cases where the plaintiffs couldn't show they had title to the debt, especially in home mortgage foreclosure actions. It was like the Wild West. I suspect that this company has got what you're looking for, and they are the owner of the debt. But I'm going to allow discovery. And I'm going to continue this matter for 60 days. That will take us into next year. Today is November 17th. I'm going to continue this to, got to be gone for a period of time in January to somewhere on the 9th parallel of latitude. So I'm going to continue this to February 2nd. At 9 a.m. Defendant requests.
I would be allowed to show up in person for that one.
Say that again.
Would I be allowed to show up in person for that then?
Certainly. You always are.
Okay.
If we have a blizzard, you might even be able to make it all the way from your house to here. Charlotte Street's not very far away from here. So hopefully we won't, but you have a legitimate question. You asked it, they didn't respond to it. Now I've ordered discovery. Let's kick the can down the road about 65 days. And we'll see where we are at that time.
All right, Mr. Pirro, you certainly. If they don't.
Say that again.
If they don't provide that in the 65 days, then
we'll deal with it further on February 2nd. In order to prevail at this matter at a trial, they'd have to prove beyond a preponderance of evidence that they own the debt. So we'll see where we go. It could either be subject to a defendant's motion for summary disposition, or I'll just set it for trial and put them to their proofs that they own the debt. We'll discuss that further on February 2nd. I get the impression Ms. Francis has a copy of the document you're looking for, that she can see it, but you and I can't. We'll see where we go. The actual law firm is Olivier and Olivier. She'll relay that information to them, and hopefully they can provide that information. Now let's assume they do own the debt, and they claim you owe $3,109.06. There can be discussions of settlement of this matter, either with a reduction for a lump sum payment or a settlement for the amount pled on a payment plan. So nothing prohibits the parties from discussing this matter prior to February 2nd. Let's assume they're right, Mr. Pirro, they own the debt and you owe it. The next question is, what do we do then? And that's when they would discuss a potential settlement. All right, Mr. Pirro, do you have any questions?
Not at this current time. I'll, continue to wait for the next date and discuss.
We'll see what you get. All right. Either way, I'll see you on February 2nd. Thank you.
Ms. Francis, I'll get a letter in the mail to remind that?
Yes, you'll get a new notice.
Okay.
All right. Very good. Thank you.
Thank you.
Thank you, sir.
Ms. Francis, you don't have to drive to Centerville on February 2nd, although I know you'd probably like to, but you can appear by Zoom for that hearing.
Thank you, Honor.
All right, thank you.
Have a good day.
Thanks. All right, I'm gonna stop the live feed and,
Gary, use car.
did you drive from Sturgis and back in this amount of time?
No, I didn't make it. I had to reschedule. So now we've got a 4:15 in Sturgis.
Okay, we'll try to be done by then. All right, we're back. All right. We're going to address a matter that was set for 11 o'clock today. People versus Sarah Marie Wainwright. The file number is 251685SD. Are you Sarah Wainwright?
Yes, Your Honor.
All right, this matter was set for sentencing at 11 o'clock this morning.
My sincere apologies.
All of these files that you see start at 11:15, at 1:15. I have a completely full docket through the end of the afternoon. The last time you showed up 5 hours late. This was better than that. It was only an hour or so late, including the times you didn't show up. I don't have time to do this sentencing. So I'm going to cancel your bond and we're going to do it tomorrow.
I take full responsibility. I'm truly sorry. I really am. It was a long drive for me as well with the flu today.
All right.
so
You have a pattern of either not appearing or appearing late. We sat here for 40 minutes waiting for you to show up. You were 5 minutes out, you were half an hour out. We had things to do. Mr. Truckee had a meeting that he missed. I had a meeting that I went late and left early because you weren't here on time. So I have lots of time tomorrow morning.
I could do that.
All right.
I really am sorry. Lots of stops at the gas station with the flu. I'm not gonna go into detail, but I am truly sorry.
Okay. Ross, how do you look for tomorrow?
I'm available first thing in the morning, 8 or 9.
Let's take a look. Judge P is back tomorrow. He has pre-exams and I have arraignments, but there's not an inordinate amount. Well, yes, there is. How about if we shoot for 9:30 tomorrow morning?
I have a 10 o'clock in Three Rivers.
Oh, all right. Yeah, we'll shoot for 9 o'clock.
Okay.
I may have to skip things. Deputy Kending, I'm having Miss Wainwright taken into custody. I'm going to cancel her bond and we will address her sentencing tomorrow morning at 9 o'clock. All right, thank you. Bye. Do you have everything you need out of your car?
Or
You don't have a dog or a cat in there, you do?
oh, not with me, no.
My son's at home. He's sick with the flu. That's where I got it, and my 2 dogs.
Is someone gonna care for your son?
He expected me to come back, so
I don't trust you to show up again. I'm very unhappy about this. You're so cavalier about it.
no,
It's like, I
I'm
think
really
there's
sorry.
more.
I'm really sick today. I really am. I truly apologize from the bottom of my heart. I don't do this often. I promise you
You
that.
did it. You
The
failed to
first
appear
time was-
twice and then you were 5 hours
Well,
late.
I was caring for my mom who has stage 4 cancer, leukemia. And at that time, my vehicle was broken down, is what had happened. This stuff never happens. It's been a bad year. I'm not making excuses. I have proof of all of this I can even show. I'm not cavalier. I just don't want to make excuses.
Which is exactly what, stop.
It
You're just
sounds
making,
like
you're just
it,
making
but-
it worse. I don't want to
I
make
understand, Your
excuses
Honor.
and you're making excuses.
Well,
Um,
it's facts, but I am also very truly sorry though. I'm upset with myself.
Ms. Canfield, do you have any input on this?
If I may have the court inquire as to the age of her child.
I believe he's 13.
It's problematic because I do recall, like, my note didn't even enter the plea because the last time I had an attorney pretrial for her, she hadn't shown up, which I believe was the day that she was 5 hours late, and then entered the plea in the afternoon. So it is problematic. She doesn't have a significant record. I understand when people are ill, and my concern is the 13-year-old son at home. I mean, they're okay for maybe an afternoon by themselves, but probably should not be left overnight. I don't know where the father is or the grandparent.
No, yeah, I've
Some-
got full custody of my son.
Like the grandparent is ill as well.
All right. We're gonna,
Please give me at least the 3rd try. I promise I will be here. And
All
I
right.
do not promise.
all right. I think when he called you, you realized it was time to leave for court. You would have left at 11 o'clock when the matter was set to get here by when you got here.
I left at 9:45, Your Honor.
I thought Garrett, Indiana was by,
We're in 15 minutes to get here, and I was at 4 gas stations. I told him for 20 minutes with my flu.
That is accurate to what she reported to me in our initial phone call this morning.
are you available Wednesday, the 19th
Yes,
at 9:30?
yes.
Make arrangements for your son and your dog and your cat. And bring your toothbrush. And we're gonna address this on Wednesday, November 19th at 9:30, not 9:35, not 9:40. I'm about to be inundated with literally,
I will be here.
they're already coming in for their 11:15. All right. What time did she actually get here?
At 12:16.
At 12:15, she texted me confirmation that she was here. We met briefly during the 12 o'clock hour in the hallway here.
Continue to 11/19/25 at 9:30. Mr. Huff, did you have the same sort of problems setting up the pre-sentence interview?
No.
So that went smoothly?
Yep, it was done over the phone.
All right. I'll see you on Wednesday morning at 9:30.
Thank you, Your Honor.
Thank you, Mr.
Thank
Trickey,
you.
for your willingness to be here now and again Wednesday morning.
Thank you.
Yes, I need orders in several, but allegedly they're coming.
Okay. I'll keep my eyes open.
All right, I think the live chat is off. I hope it is. Mr. Crick and Ms. Solomon, would you join me, please?
I'm here.
All right. First matter we're going to address is the discovery matter in Andrew Crick versus ballistics removal. The file number is 251629. Mr. Crick filed a small claims action against ballistics removal for $1,400. Had a hearing and a judgment entered in that amount. That was on September 19th. By the terms of the judgment, the plaintiff is entitled to payment within 30 days of the date of the judgment, or they can pursue collections. Nobody appeared for ballistics removal. Mr. Crick filed a subpoena for a debtor's examination for ballistics removal. Bring him, all right, put him in the Zoom room.
He's in there.
Okay. And Gregory Myers of ballistics removal was served for today's hearing personally, and he is not here. The problem is the judgment is against ballistics removal, not Anthony Myers or Gregory Myers. Gregory Myers received a subpoena. Mr. Crick, have you had any contact with Mr. Myers since the hearing?
No, I have not.
I can't very well issue an arrest warrant for ballistics removal. I can, however, do an order to show cause for Greg Myers. See how I spell that. Meyers. For failing to appear for a personally served subpoena. If he does not appear for the order to show cause, I'm going to find that he's in contempt. I'm going to issue a warrant for his arrest, but I can't arrest the company. He was personally served and he's failed to appear. So we're going to have to set a show cause hearing. If he does appear, we can conduct a discovery hearing. If he does not appear, he's subject to contempt and a warrant for his arrest. I would set bond in the amount of the debt. You have an additional $55.40 in service fees.
Let's be honest, there are zillions of things.
Did you have other costs?
No, not at this time. That was the only other thing that was added since the hearing.
All right, we're going to get another date. And if he doesn't appear for that one, I'm going to issue a warrant for his arrest. So if someone hears this on behalf of Gregory Myers of ballistic removal, I would suggest he contact Mr. Crick regarding this civil debt. All right, that's all we can accomplish here today, sir.
Okay. I have a question, Your Honor. Do you know when that will be, or I'll get that in the mail, or how? Will that
You'll get it in the mail. It might not be till after the first of the year. They're going to have to serve him again.
Okay. So I don't need to be concerned about that then?
No, it'll be probably in January.
Okay. I just want to make sure I know what's going on, that's all.
Are you still at Pleasant Street?
Correct.
All right, we'll get a notice to you there. You can appear by Zoom like this once again.
Okay.
All right, thank you.
Thank you, sir.
All right, Ms. Solomon, would you join us, please?
Yes, I'm here, Your Honor. Can you hear me?
I can hear you. I can't see you.
Okay, I'm not sure how to do that. Hold on. Start video. Can you see
There
me
you
now?
go.
Okay.
Yes.
I'm not good with this.
No, it takes some practice. Mr. Neal is here with me at the courthouse. They put him in the conference room
Okay.
in case you guys need to talk, but let me talk about this case. This is file 252219 SC, Savannah Solomon versus Ron Neal. Mr. Neal is present in the conference room and Ms. Solomon is here by Zoom. Let me explain a little bit. Mr. Neal, you might have done this before, but I don't think Ms. Solomon has. You're in small claims court. It's a separate division of 3B district court. You can sue for up to $7,000 in small claims court. Neither party is allowed to have an attorney. There's no formal record being made of the proceedings. There's no appeal from the proceedings. Any decision made here is final. There's no appeal or rehearing. The decision is final. Either party has the right to ask me to remove the matter from small claims to the general division of the court, where you could sue for up to $25,000, have the right to an attorney, and have the right to appeal. But once we begin here, the decision is final. Do you understand, Ms. Solomon?
I do.
Mr. Neal, you understand as well?
Yes, I do.
Let me give you a proper name. All right, would you both please raise your right hand? You both swear or affirm to the best of your ability and will interpret these that you will strike that. You both swear or affirm to the best of your ability that you will tell the truth to the best of your knowledge.
I will.
Yes, I will.
All right. I was giving you the interpreter oath, which we do quite often. We don't need an interpreter. All right, I had to study this case a little bit to see if I could figure out what was going on. This is a claim for $6,463.19. Miss Solomon was in an automobile accident where somebody crashed into her car, Constantine Road at Featherstone, I think it was.
Yes, Your Honor.
And sustained damage to her car. The car was driven by Adam Kaler of Maple Crest Apartments. The car belonged to Ron Neal, and allegedly the car was uninsured. Mr. Kaler got a ticket, which I looked up, which is file number 25907537SI. He got a ticket and promptly failed to respond to it. So he's about to get defaulted for failing to answer his traffic ticket. Failing to yield as a civil infraction. Under Michigan law, if you are not insured and you're in an automobile accident, you're not covered by the no-fault statute. And the plaintiff can sue for the entire amount of the damage. Under the current status of the mini tort law, they can sue for up to $3,000 for damages, but not the entire amount. We get lots of these cases because we have literally hundreds of uninsured drivers driving around with no insurance, hundreds. And several times a year, one of those people gets in an automobile accident and causes substantial damage, and the other party's insured then sues them for $24,000. The accident report contained with the
I even started to notice some of the hair growing back at the end of the
claim says that the defendant had auto owner's insurance, the plaintiff, Ms. Solomon, had auto owner's insurance, and that Mr. Kaler's automobile, which was owned by Mr. Neal, says it was insured by West Bend Insurance. Mr. Neal, in his answer, claims that the vehicle was insured by West Bend Insurance. So, Ms. Solomon, well, first of all, let me start with you, Mr. Neal. Who is Adam Kaler to you? Somebody that was buying a car from you?
Yes, he was on a demo ride that morning, and I put him on in the pickup on a dealer plate, and they go out and drive 10, 15 minutes. Well, 20 minutes later, he called me and said there was an incident. When he came back and everything settled down, he ended up taking delivery of another vehicle that day. But that's who Adam is to me.
All right, Ms. Solomon.
Yes,
Mr.
Your Honor.
Neal contends that he is insured by West Bend Insurance Company.
Yes, Your Honor.
Tell me what you know about that.
Well, I reported the incident to my insurance, and Julie forwarded the information on 8/21 to West Bend, and they called me and my mom. My mom was a witness as well because she was in the vehicle, and they got my statement and they recorded it. Called them again.
Now,
and
who is that? Who is they?
The West Bend insurance people. I didn't get a name for who
The lady was.
yeah, the lady that took my statement.
Mine.
Okay.
So I did, but Ron said he didn't want to make a claim because he didn't want his insurance to go up, but he was going to fix the truck himself.
Yeah.
So I'm not really sure who's going to pay for my car and like the court costs.
Well, if he's insured,
Yeah, is it the insurance?
then your insurance pays for it.
Well, I guess
He, under the no fault statute, you're in an accident with somebody else, he pays his damages and you pay your damages. If he elects not to make an insurance claim for his vehicle, that's on him. If he decides he'd rather just fix it than make a claim for it, he can do that. But his insurance company doesn't cover you. So apparently he is insured by West Bend Insurance, which means you can't sue him for this entire amount. However, you can sue under the mini tort statute, even if he is insured, for $3,000.
Yeah, Your Honor, I just want the value of my car. I don't want anything more. I've been without a car since August 13th.
Mr. Neal, what's your response?
Well, from what I called my insurance agency this morning and talked to Lucas Shingle Decker at Preferred Insurance. And I had asked him if a claim had been filed, if she had filed a claim against West Bend against me, so she can get up to the $3,000.
Yeah.
And it goes back to a month or so ago, or a month and a half, when I received this letter. I got a hold of him and I said, hey, where are we at here? And he told me what she had to do. And I had talked to her about 2 weeks after the incident. And I had talked to Lucas, and Lucas told me what to do. I told her, called her back, gave her the information, and then I didn't hear nothing until I received the letter in the mail. And I called Lucas. I said, was there a claim filed against West Bend? He goes, they know about it, but there hadn't been a claim yet. The paperwork wasn't completely filled out. I said, okay. I said, I'll call you the day of we come to court. So this morning I called him, and he said paperwork has not been completed yet. And that's all I really know,
All right. Well, you have auto owners. Did you make a claim with your insurance company?
Nobody wants a stained, dirty toilet.
Ms. Solomon?
Oh, yes, Your Honor.
All right.
But, Your Honor, my mom's here. Can she be here?
Oh, sure.
Okay, she's going to explain the insurance because she was helping me with this.
Well, Mr. Neal's correct.
Okay.
Normally, you make a claim with your insurance.
And yes,
if
I
he's
did.
if he's insured,
You did.
then you can't sue him for the entire amount. However, your company could make a claim against his company for $3,000 under the mini tort statute. So it sounds like that's in the works. But you can't sue Mr. Neal for $6,463 for this damage because he was insured. He's in the business of selling cars and he has a blanket insurance policy. And this dumb kid went out and crashed into your car, got a ticket, blew off the ticket. It's now almost December. He hasn't answered to the ticket he got in August. He's going to get a default judgment. But if auto owners makes a claim against West Bend, I believe they'll pay the $3,000 mini tort limit.
Yeah, all I know is my insurance said that they faxed the information to West Bend and that they have it and that they would take care of it. So that's, yeah, they called us for the statement. So that's why I'm just confused on how to go about this.
What I'm going to do is continue this. I don't really want to do a judgment against Mr. Neal right now. He didn't do anything wrong.
Yes,
he
I
insured his
agree.
vehicle. He let a customer test drive it, and the customer didn't do too good. He's been dealing with his insurance company. Your company is dealing with his insurance company. I think what you're going to get out of this, Ms. Salmon, is the mini tort limit of $3,000. But I don't want to enter a judgment against Mr. Neal because it'll go on his credit. And you sued him personally. I'm going to set this out. I'm going to continue this.
Okay,
to
thank you, Your
January
Honor. Yeah, I don't want to.
26/2026 at 3:00. Hopefully by then the insurance companies will have worked this out.
What would you suggest that I do? Should I try to contact West Bend again?
No, you contact your own insurance company.
Okay.
Mr. Neal's talking to West End. Tell them that did you tell your insurance company you were filing a small claims action?
Yes, I did, Your Honor.
It wasn't your fault. Don't do anything.
I don't know exactly what kind of coverage Mr. Neal has. My son got in an accident in a car that I owned. He ran through an intersection and hit someone. She was very angry, very, very angry. And there was no drugs or alcohol or anything involved. He just wasn't paying close attention. My insurance company simply paid the mini tort limit and that was the end of it. I'm not sure what kind of policy Mr. Neal has, but hopefully they'll do that. If they don't, I can enter a judgment against him in the amount of $3,000, which is the mini tort limit. Then he can turn it into his insurance company and see whether they'll pay it. I'm trying to do this without having a judgment enter against Mr. Neal, seeing if the insurance companies can just deal with it.
Yes, thank you.
All right, you haven't lost, well, you're not going to get everything you asked for because he's insured.
Yes.
So the no fault law controls. But even with a no fault law, you can still sue for $3,000. So Mr. Neal, you need to see if you can get your insurance company to react to this. Perhaps just settle it with auto owners. If not, then we'll deal with it further on January 26th. Do you have any questions?
You say that's January 26th?
Yes, at 3:00.
Okay. So I need to get a hold of my West Bend.
Yes.
and give them her name and the case number? or
Yes,
whatever,
and her, yep. Do you have a copy of that accident report?
She did give me, or you did, I do have
Yes.
one here.
All the information of the companies is on there.
Okay. Okay. And then, do I get back a hold of her then, or am I supposed to be in contact with her after I talk to West Bend? Or
Do whatever West End tells you to do. Hopefully, West End will simply, it's gonna auto owners is gonna reimburse her for her loss.
Okay.
Then at some point, auto owners may, they aren't gonna let her double dip. They aren't gonna give her $6,000 and then West End gives her $3,000. But let's see if we can get somebody made whole.
Okay.
All right. What's your name, sir?
I'm Lucas. I was just here. I didn't realize this was digital. If they had any, Ron had any questions, I was here to help them out.
Oh, all right. Well, come on up here.
Where should I go?
Right over there is fine. How are you connected to this?
I'm his agent.
Oh, all right. Lucas is here from West End, so that's very helpful.
If there was only one supplement, God forbid, that I could take.
Well, we've learned. Lucas, what's your last name?
Shingledecker.
Oh, yeah, we met before.
Yeah.
Would you raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
All right. What we know is that there was an accident at Constantine and Featherstone Road. Mr. Neal was allowing a customer, Mr. Adam Kaler, to test drive a truck. Mr. Kaler ran a red light or a stop sign and he hit Ms. Solomon. He got a ticket for failing to yield, which he has not responded to. Ms. Solomon has submitted a quote of damages, the amount of $6,463.69. She can't sue Mr. Neal for that entire amount because he's insured and he's covered under the no-fault statute. So do you confirm that Mr. Neal's vehicle was insured that day, the day of the accident?
Yes, it was.
All right. So what she can sue for is the mini tort limit of $3,000. She's covered by auto owners. It sounds like auto owners has been in contact with West Bend. So what I did is I continued the matter to January 26th to see if auto owners in West Bend can work this out so that Mr. Neal doesn't get a judgment against him. Does that make sense to you?
Yes, and they should.
All right, you think West Bend will pay the mini tort amount?
Yes, I've never had a situation where they didn't.
All right. Thank you for being here. It's very helpful. All right, we're all on the same page. Mr. Shingledecker knows what Mr. Neal needs. Ms. Solomon, you can let your insurance agent know we had this hearing. January 26th. And let's see if you guys can get this sorted out. Whoever needs to be paid the $3,000, whether it's auto owners or Ms. Solomon, will be paid. Mr. Neal won't have a judgment against him. And you guys can all live happily ever after.
Okay, thank you so much, Your Honor.
All right, and Mr. Shingledecker, thank you for being here. That helped paint the whole picture.
Yeah, no problem.
All right, you're good to go. And Mr. Neal, good luck to you.
Thank you.
All right, very good. All right, well, hopefully we won't be here because the thing will be settled, but if it isn't, as I indicated, Mr. Kaler got a ticket and he hasn't paid it or even responded to it. Oh, jeez. That's ticket number 25907-537 SI. All right, you guys are all good to go. Thank you, Ms. Solomon.
Thank you. Have a good day.
Okay. Mr. Neal, you're
Well, that's it for today, everybody. I broadcast every day at 3 o'clock p.m. Central Daylight Time, 4 o'clock Eastern Time. If you like the content that's on this channel, please do me a favor and subscribe to this channel and help this channel grow. I would like to see 100 subscribers before the end of December, before January 1st. I know we can do it. So that's it for today. I will see you guys tomorrow. Ciao, ciao, ta-ta, and have a good rest of your evening.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. You make it better. From the wires tangled up to the broken dreams. You know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Make it right. When the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time.